Brianna McNamee. She has 3 separate cases. Cases 23, 1292, 24189, and 24190. We're here today for a change of plea. It's anticipated by the state of Ohio that the defendant will enter pleas of guilty to the following. On 23-1292, she'll enter pleas of guilty to counts 1, 2, and 5. On case 24 CR 189, she'll enter pleas of guilty to counts 1, 2, and 3. And on file 24-190, she'll enter plea of guilty to count 1. And we ask the court to dismiss the remaining counts at sentencing, and there is an agreed prison term of 27 months. Thank you.
Mr. Mathis, does that sound accurate?
Yes, Your Honor.
Ms. McNamee, were you able to hear what the prosecutor had to say regarding what he believes your intentions are regarding these 3 cases?
Yes.
He indicated to the court he believes that your desire to withdraw your previously entered pleas of not guilty and enter pleas of guilty to certain charges in each of these cases, and I'll go over those each with you to make sure we're on the same page and you understand what these charges are, and that the other counts would then get dismissed. Having a hard time hearing me?
No.
We would then proceed straight to sentencing. It's been represented you're going to waive the preparation of a pre-sentence report. We proceed straight to sentencing, where a joint recommendation of 27 months for all 3 cases will be recommended to the court. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
Yes.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine these issues, I will ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to speak with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Okay.
All right. Let's get started then. How old are you?
27.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
1 prescription medication.
What's that?
It's for night terrors. It's a heart, a blood pressure medication. I don't recall the name. They just put me on it yesterday.
Oh, just yesterday?
Yeah.
So when did you last take it?
Last night.
It's blood pressure medication, though?
Yeah.
Anything else?
Nope, that's all.
You just started it. Has that medication affected you at all in any way which hinders your ability to understand or appreciate where you are, or what's going on, or to communicate with people, anything like that?
No.
Now, you would have received copies of each of the indictments in this case. Did you get those indictments, the documents that set forth what the charges are?
Yes, I did.
And at some point, did you have the chance to look those over?
Yes.
All right, in this first case, 23 CR 1292, you're charged with 7 counts. You're pleading guilty to 3 of them. Count 1, which is one of the offenses you're pleading guilty to, What's alleged here and what you'll be admitting to is on or about October 18th, 2023 in Mentor Lake County, Ohio, that you did knowingly sell or offer to sell a fentanyl-related compound or a mixture, preparation, or substance containing a fentanyl-related compound. The amount involved equal or exceeded 1 gram, but was less than 5 grams. It was 2.10 grams, which makes the offense trafficking in a fentanyl-related compound a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes.
Any questions about it?
No.
Now, count 2 is another charge you're pleading guilty to here and alleges on or about November 16th, 2023 in Fairport Harbor, Lake County, Ohio, that you did knowingly sell or offer to sell a fentanyl-related compound or a mixture, preparation, or substance containing a fentanyl-related compound. The amount exceeded 1 gram, but was less than 5 grams. This time it was 2.85 grams. But it's also alleged this offense was committed in the vicinity of a school, which makes the offense trafficking in a fentanyl-related compound a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes.
Any questions about it?
No.
Lastly, count 5 is just the 3rd count you're pleading guilty to in this indictment. Alleges on or about November 30th, 2023 in Fairport Harbor, Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or a compound, mixture, preparation, or substance containing cocaine. The amount did not equal or exceed 5 grams. It was 0.93 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 5?
Yes.
Any questions about that?
No.
Now, there are 4 other counts of this indictment. Those are all being dismissed pursuant to the agreement. Is that your understanding?
Yes.
Any questions about those 4 other counts?
No.
All right, and the next case is 24 CR 189. You're charged with 6 counts. You're pleading guilty to 3 of those. Count 1, which is one of the counts you're pleading guilty to, alleges on or about August 2nd, 2023 in Willoughby Lake County, Ohio, that you did knowingly sell or offer to sell cocaine or a compound, mixture, preparation, or substance containing cocaine. The amount did not equal or exceed 5 grams. It was 3.42 grams, which makes the offense trafficking in cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes.
Any questions about it?
No.
Count 2 alleges on or about August 2nd, 2023 in Willoughby Lake County, Ohio, that you did knowingly sell or offer to sell methamphetamine or a compound, mixture, preparation, or substance containing methamphetamine, which is a Schedule II controlled substance. The amount involved equal or exceeded the bulk amount, but was less than 5 times the bulk amount. Specifically, it was 3.3 grams, which makes the offense aggravated trafficking in drugs a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes.
Any questions about it?
No.
Lastly, for this case, in count 3, it's alleged on or about August 2nd, 2023 in Willoughby Lake County, Ohio, that you did knowingly sell or offer to sell a fentanyl-related compound or a mixture, preparation, or substance containing a fentanyl-related compound. The amount equal or exceeded 1 gram, but was less than 5 grams. Specifically, it's 2.02 grams, which makes the offense trafficking in a fentanyl-related compound a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in regards to count 3?
Yes.
Any questions about that?
No.
Now, there are 3 other counts in this indictment that are all being dismissed. Is that your understanding?
Yes.
Do you have any questions about those 3 charges?
No.
All right. Lastly, in case 24 CR 190, you're charged with 2 counts. You're pleading guilty to one of those counts, count 1, which alleges on or about January 19th, 2023 in Eastlake, Lake County, Ohio, that you did knowingly aid or abet Tanner McGee to commit the offense of aggravated trafficking in drugs, a felony of the 3rd degree. It's alleged that the amount of methamphetamine involved in this equal or exceeded 5 times the bulk amount, but was less than 50 times the bulk amount. It was 3.27 grams, which makes the offense complicity to aggravated trafficking in drugs, a felony of the 3rd degree. Understand what you're charged with and pleading guilty to in regards to count 1 here?
Yes.
Any questions about it?
No.
There is another count in this indictment of aggravated possession of drugs that's being dismissed. Is that your understanding?
Yes.
Any questions about that?
No.
So you understand the nature of ultimately it's 7 separate charges that you're pleading guilty to here?
Yes.
Any questions about any of those?
No.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And these rights I'm about to explain to apply to all three cases. I'm not going to go over them 3 times. If there's anything that applies to one case or 2 and not the other, I'll make sure I point that out. I don't think that's the case, but if there is anything, I'll do that. But otherwise, everything I'm explaining to you applies for all 3 cases.
Okay.
And let's start with the first right that you have, and that's the right to have a trial. And a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty of each separate charge. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, as to each charge, whether you were guilty or not guilty. Do you understand that?
Yes.
Do you understand that by pleading guilty, you are giving up your right to have a trial?
Yes.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and he would have what we call the burden of proof. Now, with him having the burden of proof, what that actually means is that it's his job, or he bears the responsibility or the obligation of proving you guilty at a trial before you could ever be found guilty. You are presumed innocent of the charge, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, I speak of this burden of proof since this is a criminal case. The burden of proof is what we call proof beyond a reasonable doubt, which is the highest burden we have in our justice system. And what it actually means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes.
Do you understand that by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least in order to try to do that if we had a trial, the prosecutor would be calling witnesses to come into court and testify for the state and answer questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that is called cross-examination. So he could ask him anything he wanted to within certain rules. Do you understand that?
Yes.
Do you understand that by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come in court and testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you do have the right to do that. Do you understand that?
Yes.
You also have the right, if there was someone out there that you wanted to have come into court to testify for you who wasn't willing to come in voluntarily on their own, you could request the court issue an order that we call a subpoena, which would force or make them come to court and testify for you and answer your lawyer's questions again if they didn't want to come in willingly. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision. That's a choice that you would have to make. So what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, he would not be allowed to call you as a witness and make you get up on the stand and testify and answer questions. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that's above me. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all then regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
You understand that your guilty plea is a complete admission of guilt. That means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty in this first case, 23 CR 1292, to 3 charges: a felony to the 3rd degree, 4th degree, and 5th degree. Count 1 is the trafficking in a fentanyl-related compound, a felony to the 4th degree. It's punishable by a possible term in prison of a minimum of 9 months, a maximum of 18 months, or any whole number in that range of 9 to 18. Do you understand that?
Yes.
Now, count 2 is a trafficking in fentanyl-related compound in the vicinity of a school, which is a felony to the 3rd degree. This carries with it a possible term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, or 30. So if I impose a prison sentence in this count, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you'd have to serve for this count. Do you understand that?
Yes.
Lastly, count 5, the possession of cocaine charges a felony to the 5th degree. That carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes.
Now, since there are 3 separate charges here, 3 incidents, if I impose a prison sentence, I would impose a prison sentence on each of those 3 counts. And as the judge, I have the discretion to run those sentences either concurrent or consecutive to each other. Concurrent means you serve them together at the same time, whereas consecutive means one after the other. Do you understand the difference there?
Yes.
So in this case, if I impose the maximum sentence on each count and ran each count consecutive, you're looking at a maximum possible prison sentence in this case of 66 months, which is 5.5 years in prison. You understand that?
Yes.
Now in case 24 CR 189, they're pleading guilty to 3 counts. Again, it's very similar to the last case. There's one of each, a felony 3rd degree, 4th degree, 5th degree. The trafficking and cocaine charge in count 1 is a felony to the 5th degree, punishable by a possible term in prison of 6 to 12 months. The aggravated trafficking in drugs, which is the methamphetamine charge, is a felony to the 3rd degree, carries with it that possible term of either 9, 12, 18, 24, 30, or 36 months. And the trafficking in a fentanyl-related compound in count 3 is a felony to the 4th degree, carries with it a possible term in prison of 6 to 18 months. Again, I have that same discretion to run the sentences concurrent or consecutive to each other, so the maximum possible sentence you face in this case is also the same, 66 months or 5.5 years in prison. You understand that?
Yes.
Lastly, in 24 CR 190, you're pleading guilty to 1 felony to the 3rd degree. It's the aggravated trafficking in drugs with the methamphetamine. It carries with it, again, a possible term in prison of a minimum of 9 months, maximum of 36 months, or increments in between of either 12, 18, 24, or 30. Do you understand that?
Yes.
Now, just as I explained a moment ago in regards to the charges within the same indictment that I could run a prison term concurrent or consecutive, I could also run prison terms between the 3 cases concurrent or consecutive to each other. You understand that?
Yes.
I can run 2 of the cases concurrent and 1 consecutive. I can do a whole combination of whatever I think is the right thing to do. But in regard to all 3 of these cases, if I was to give you the maximum sentence on each of the 7 counts you're pleading guilty to and ran them all consecutive to each other, you're looking at a maximum possible prison sentence of 14 years in prison. You understand that?
Yes.
Now, are you currently on probation or parole to any other courts or agencies?
No.
Do you have any other charges pending against you at this time?
No.
If a prison sentence is imposed in any of these cases, upon your release from prison, you could be placed on post-release control, which is sometimes referred to as parole, and it could be for a period of up to 2 years. You understand that?
Yes.
What that is, again, it's a period of supervision you would be on after you served and completed the entire prison sentence. And for all 3 of these cases, each one would be a possible 2 years of post-release control. You understand that?
Yes.
And if you are put on post-release control and you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentence that I just mentioned, there's other sanctions that could be imposed here. You could be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes.
Also, there's a possible driver's license suspension in each of these cases, that your license can be suspended up to 5 years. Do you understand that?
Yes.
And also, there's some fines involved here. In the first case, 23-1292, count 1, trafficking in fentanyl related to felony of the 4th degree is a possible fine of up to $5,000. Count 5, the possession of cocaine charge is a possible fine of $2,500. And count 2, the trafficking in fentanyl related compound that's a felony of the 3rd degree has a mandatory fine of at least $5,000 that has to be imposed, and you could be fined up to $10,000. You understand that?
Yes.
So this case carries with it a fine that will be imposed of at least $5,000, but it could fine you up to $17,500. Do you understand that?
Yes.
Now, in case 24 CR 189, it's the exact same thing. The trafficking in cocaine charge could be a possible fine of up to $2,500. The trafficking in fentanyl-related compound could be a possible fine of $5,000. And the aggravated trafficking and drug charge with the methamphetamine carries with it a mandatory fine of at least $5,000 up to possibly $10,000. So again, in this case, a fine of at least $5,000 will be imposed, and you could be fined up to $17,500. You understand that?
Yes.
Lastly, in 24 CR 190, there is a mandatory fine of at least $5,000 that has to be imposed up to a possible fine of $10,000. Do you understand that?
Yes.
So in this case, with all three of the different cases, there'll be a fine of at least $15,000 imposed, and you could be fined up to $45,000 total. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison's not mandatory for any of these cases or any of the charges. You are eligible for probation or what is called community control sanctions. Do you understand that?
Yes.
Now, do you understand that just because you're eligible, that doesn't mean you would automatically get probation if you were requesting it? And I would consider that if that's what you were asking for. I look at all the information presented, then I make the decision I thought was the right thing to do. Do you understand that?
Yes.
Now, even though you're eligible for probation, the felonies of the 3rd degree in each of these 3 cases all carry with it what's called a presumption for prison, which means the court would have to, it's presumed the court would have to impose a prison sentence unless certain findings could be made that would overcome that presumption, override that presumption, and allow me to put you on probation. You understand that?
Yes.
Further, in order to be considered for probation, a pre-sentence report and investigation has to be completed. That's a report the probation department puts together for my benefit, to give me information about you and your background. The way, but that report is a prerequisite in order for a judge to be allowed to consider probation. You understand that?
Yes.
Now, it's been represented to me that you're waiving the preparation of a pre-sentence report, meaning there's not going to be a report completed in this matter. Is that correct?
Yes.
So do you realize that even though each of the offenses you're pleading guilty to are probationable offenses, I will not be able to consider probation as an option when we go to sentencing?
Yes.
Lastly, when we do proceed to sentencing, you're going to have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. He can recommend a sentence to the court. The prosecutor could also recommend a sentence to the court. Do you understand that?
Yes.
Do you understand that whatever the attorneys say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all regarding these potential penalties you face by pleading guilty?
No.
Do you understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to talk about this case with your lawyer, have him review the reports with you, discuss the issues, and answer your questions?
Yes.
Has your lawyer made any promises to you regarding what's going to happen at sentencing, or has anyone made any promises to you regarding what's going to happen at sentencing, which is inducing you to plead guilty here today?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, then, do you have any questions for me at this time regarding anything we've just talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No.
Do you need any more time to speak with your lawyer before we go forward with your actual plea?
No.
All right, then what we're going to do here at this time is the prosecutor here is going to explain for me what he believes the evidence would show in each of these cases, and we'll do one case at a time to make it easier. But I need you to listen to what he says because I'll have some follow-up questions for you, all right?
Okay.
All right, Mr. Geiger, why don't we just start with the first case, 23 CR case, 1292.
On 1292, the evidence would show that that the defendant was targeted by Lake County Narcotics with an undercover confidential informant. The evidence would show that on October 18, 2023, the defendant set up a deal for 20 fentanyl pills for $150. The exchange was to take place at 777 Reynolds Road in the city of Mentor, Lake County, Ohio, which is Sheets. The deal did in fact occur, but it was shifted to 7745 Reynolds Road, which was the speedway where she exchanged the fentanyl pills for the currency. They were sent to Lake County Crime Lab where it tested positive for 4 AMPP/fentanyl, an amount of 2.10 grams. Second, she was again targeted on November 16, 2023 for a deal of 30 pressed pills for $180 plus $20 in gas money. Deal occurred at 328 7th Street in Village of Fairport Harbor, Lake County, Ohio. The deal did in fact occur. The items were sent to the Lake County Crime Lab where it tested positive for 2.85 grams or 26 unit doses of 4 AMPP fentanyl. And it also occurred within 1,000 feet of McKinley Elementary School. And subject to controlled by, the defendant was subject to a traffic stop by Lake County Narcotics. They recovered a bag of suspected meth, digital scale, $237 in U.S. currency, a glass pipe, and a cell phone. I mentioned these items only for the fact that they're going to be forfeited. The items were sent to Lake County Crime Lab where it tested positive for cocaine, 0.93 grams.
Thank you. Ms. McNamee, were you able to hear what the prosecutor had to say regarding what he believes the evidence in 23 CR 1292 would show regarding counts 1, 2, and 5 if we had a trial?
Yes.
What, if anything, do you have to say about those facts as he presented them? Are they true? Did you do what he said?
Yes.
Very well, then. In regards to count 1, charging with trafficking a fentanyl-related compound of felony the 4th degree, what is your plea to that count?
Guilty.
In regards to count 2, charging with trafficking a fentanyl-related compound in the vicinity of a school, a felony of the 3rd degree, what is your plea to that count?
Guilty.
In regards to count 5, charging with possession of cocaine, a felony of the 5th degree, what is your plea to that count?
Guilty.
All right. Mr. Gragos, let's move on to 24 CR 189.
Thank you, Your Honor. And the evidence would show that on August 2nd, 2023, the defendant was again targeted by a confidential informant where a deal was set for cocaine, methamphetamine, and heroin for $400. The deal was to occur at 36195 Euclid Avenue in the city of Willoughby, Lake County, Ohio at the Target. The deal did in fact occur. The suspected narcotics were sent to the Lake County Crime Lab where it tested positive for cocaine, an amount of 3.42 grams, methamphetamine, an amount 3.3 grams, and fentanyl, an amount of 2.02 grams. Thank you.
Thank you. Ms. McNamee, were you able to hear what the prosecutor just had to say regarding what he believes the evidence would show in case 24 CR 189?
Yes.
And what, if anything, you have to say about these facts as he presented them? Are they accurate? Did you do what he said?
Yes.
Very well, then regarding count 1, charging with trafficking cocaine, a felony of the 5th degree, what is your plea?
Guilty.
Regarding count 2, charging with aggravated trafficking drugs, a felony of the 3rd degree, what is your plea to that count?
Guilty.
Regarding count 3, charging with trafficking a fentanyl-related compound, a felony of the 4th degree, what is your plea to that count?
Guilty.
All right, Mr. Geigers, the last case, 24 CR 190.
Thank you, Your Honor. The evidence would show that on January 19, 2023, the defendant, along with Karen Owens and Tanner McGee, were subject to an undercover informant. A deal was set for 1/8 ounce of methamphetamine for $90. The deal occurred at 1332 East 351st Street in the city of Eastlake. McGee set up the deal. Karen Owens took the money from the confidential informant, and the defendant served up or provided the hand-to-hand transaction for the narcotics. They were sent to the Lake County Crime Lab, where test positive for methamphetamine Schedule 2, an amount of 3.27 grams. Thank you.
McNamee, were you able to hear what the prosecutor just had to say regarding what he believes the evidence would show in this case, with this one count, if we went to trial?
Yes.
And what, if anything, do you have to say about the facts here as he just represented them? Are these facts true as well? Did you do what he said?
Yes.
Very well, then, regarding count 1 in case 24 CR 190, charging with aggravated trafficking in drugs, a felony of the 3rd degree, drugs being methamphetamine. Hang on one second. Complicity to aggravated trafficking in drugs. I said the wrong offense. Aiding and abetting someone. That's what the charge is in count 1. You have the aggravated trafficking in here. On the change of plea form, it says aggravated trafficking in drugs.
Oh, I wrote
It's
down
actually
aggravated,
huh?
but the indictment is actually complicity, correct?
I know.
Oh, then I messed up, I'm sorry.
That's what I'm.
You want me to
That's what I'm trying to
correct
nicely
it,
say.
or?
I got it. So, Ms. McNamee, in this case, the 24 CR 190, I think I've been referring to it as aggravated trafficking in drugs. It's actually complicity to aggravated trafficking in drugs, which means you aided and abetted another in committing the offense.
Yes.
It's the person that aids and abets someone in committing an offense is just as guilty as the person that is the principal offender and does it. So there's not a difference in the penalty or the degree of offense. I was just referring it as the wrong name when I was referring it to you. But that's what you're actually pleading guilty to in this case, complicity. You understand that?
Yes.
All right. So let me ask you then, in regards to count 1, charging with complicity to aggravated trafficking in drugs, the drugs being methamphetamine, a felony of the 3rd degree, what is your plea to that count?
Guilty.
All right, I have in my possession here at this time 3 documents. They're each called a written plea of guilty and judgment entry, and they're pretty, very, very similar in regards to the fact that they all explain what the rights are that I just talked to you about, the possible penalties you face. Obviously, the penalties are different for each case depending on what the charges are. They also set forth the charges. I did correct the case in 24 CR 190 to say it's complicity to aggravated trafficking in drugs, and I put the correct revised code section there. My understanding is before I came out here, you had a chance to go over these documents with your lawyer. Is that correct?
Yes.
Because before I can accept your plea, I need to make sure you understand everything that's in these documents. Mr. Matthews, did you review these documents with your client?
Yes, Your Honor.
You read them over and reviewed them with her?
I did.
Did she indicate an understanding of them to you?
She did, Your Honor.
Is that correct, Ms. McNamee? You understand what these documents say?
Yes.
Any questions for me?
No.
I did add into each of these documents, the only change I made, where you told me, it says you've not taken any drugs or alcohol in 48 hours, I said except for blood pressure medication. I added that language to each of the 3 counts. And then I did change the one case to say complicity to aggravated trafficking. Otherwise, they're identical to what you went over with Mr. Matthews.
Okay.
But you understand what they say?
Yes.
Any questions from me?
No.
Now, it appears on each of these documents that you signed each document. Did you in fact sign each document?
I did.
Mr. Matthews, did you witness that?
I did, Your Honor.
Mr. Geigerich, you as well?
I did, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, made a knowing, intelligent, voluntary waiver of all those rights. Court also finds the defendant does understand the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all of this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, and in case 23 CR 1292, I'll find the defendant guilty of count 1, trafficking in a fentanyl-related compound, felony of the 4th degree in violation of 2925.03A1. Count 2, trafficking in a fentanyl-related compound in the vicinity of the school, the felony of the 3rd degree in violation of 2925.03A1. And count 5, possession of cocaine, a felony of the 5th degree in violation of 2925.11. As for 24 CR 189, I'll accept the defendant's plea and find the defendant guilty of count 1, trafficking in cocaine, a felony of the 5th degree in violation of 2925.03A1. Count 2, aggravated trafficking in drugs, the drugs being methamphetamine, Schedule 2 controlled substance, that being a felony of the 3rd degree in violation of 2925.03A1. And count 3, trafficking in a fentanyl-related compound, a felony of the 4th degree in violation of 2925.03A1. Lastly, I'll accept the defendant's plea in case 24 CR 190 and find the defendant guilty of count 1, complicity to aggravated trafficking in drugs, the drugs being methamphetamine, a Schedule 2 controlled substance, making this a felony of the 3rd degree. It's in violation of 2923.03A2 and 2925.03A1. All the remaining counts in each of the 3 cases will all be dismissed at this time. Mr. Matthews, is there any reason that we should not proceed to sentencing at this time?
No, Your Honor.
It was indicated during the plea as well as in the court in chambers that your client wants to waive a pre-sentence report. Is that correct?
It is, Your Honor.
Is that correct, Ms. McNamee?
Yes.
As I explained to you a few moments ago, that means that even though you're eligible for probation in each of these cases, I will not be able to consider that as an option without a pre-sentence report. You understand that?
Yes.
And you still want to go forward with sentencing?
Yes.
Very well then, Mr. Matthews. Is there anything you'd like to say on behalf of your client?
Yes, Your Honor, thank you. As indicated, we do have a joint prison recommendation in this case. On each of the, 3 cases, we would be requesting a prison sentence of 9 months. On the 1292 case and the 189 case, we would ask that those 9-month sentences for each individual charge be run concurrent to one another. We would then be asking for a 9-month sentence on the 24 CR 190 case. We are asking that the 9-month sentences in each case be run consecutive to one another for a total of 27 months in prison. We would ask the court to adopt that recommendation.
Thank you.
If I may add, Your Honor, I'm sorry. Each of these cases does have a mandatory fine attached to it. I'm going to have Ms. McNamee complete affidavits of indigency, on each case, and we will be submitting those to the clerk's office.
Well, as long as those are filed before the sentencing entry is filed, then the court will be able to consider those.
Thank you.
Ms. McNamee, you have the right to address the court before you are sentenced, and you can say anything you want. Is there anything you'd like to say at this time?
I would just like to apologize to the court. I'm not proud of my behavior. I know that I made mistakes, and I take full responsibility for it. And I just want to move forward with my life and go back to recovery and just doing better. That's all.
Mr. Matthews, anything else you want this court to consider?
No, Your Honor.
Mr. Gogridge for the state of Ohio.
Thank you, Your Honor. The state of Ohio would ask the court to adopt the joint recommended sentence. Thank you.
And that was in the same manner as laid out by Mr. Matthews, 9 months on each case, all consecutive.
Yes, Your Honor.
So, Mr. Matthews, with this joint recommendation, you're agreeing to the consecutive sentences between the three cases,
We are, Your Honor, yes.
if that was to go along with that, obviously.
Yes. I just want to make sure I'm answering, what did you
Yeah, I mean,
say?
if I didn't go along with it and ran a bunch of stuff consecutive, you're not agreeing to that.
No.
You're agreeing to
We are
9
agreeing
months on each case consecutive to each other.
we are agreeing to the outlined terms of the joint recommendation, Your Honor, yes.
Your Honor, would the joint recommended language be sufficient for that, or do I need to say consecutive by?
I would say, whatever you normally put, the agreed recommendation, including the nature of the consecutive sentences imposed, just add
Okay.
that language, including, that's what I've been adding when I get these. Which includes the nature of the consecutive sentences the court imposed. This court has considered the facts and circumstances of the charges in each of these three cases, the nature of all the offenses, as they were related to the court during the plea here. I've considered what's been said here in court by Ms. McNamee, the joint recommendation presented by the attorneys. This is all considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, the court notes that the charges set forth in each of these cases, the defendant acted as a part of organized criminal activity, which is a factor that makes the offenses more serious. Nothing makes them less serious. As for recidivism factors, there's no factors present that at least related to the court, which would indicate defendant's more likely to commit crime in the future. As for less likely, the court notes that the defendant does not have any prior criminal history and led a law-abiding life up until these charges. Court finds prison is consistent with the purposes and principles of sentencing. The defendant's not amenable to an available community control sanction. The court further notes the defendant did waive a pre-sentence report in each of these three cases. Thus, she's not eligible for community control sanctions. Therefore, will be the sentence of this court that in case 23 CR 1292, the defendant serve a term in prison of 9 months on count 1, 2, and 5. I'll run each of those counts concurrent with each other. In this particular case, she has credit for 89 days served, which goes back to the day of her arrest on November 30th. That was the day you were arrested, correct?
Yes.
I just added all that up, so that's 89. In case 24 CR 189 is the sentence of this court, the defendant serve a term in prison on counts 1, 2, and 3 of 9 months on each count to be served concurrent with each other. The 9-month sentence imposed in this case shall be served consecutive to the prison term imposed in 23 CR 1292. Thus, there's no credit in 24 CR 189. Lastly, in 24 CR 190 is the sentence of the court. Defendant serve a term in prison of 9 months. That sentence shall be served consecutive to the prison terms imposed in case 23 CR 1292 and 24 CR 189. There's no credit in this case since all the credit is being given in the first case. For each of these cases, I need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. Case 24 CR 190, the court imposes a mandatory fine of $5,000. In 24 CR 189, I impose a mandatory fine on count 2 of $5,000. And the first case was on count 1. And in 23 CR 1292, I impose the mandatory fine on count 2 of $5,000. Defendant's ordered to pay all costs. Court disapproves the defendant's placement in a program shock incarceration, intensive prison program, or transfer to transitional control. And again, the consecutive sentences imposed were by agreement between the parties, and thus no additional findings are required. I think that covers everything. Is there anything else for the record or that we need to address, Mr. Geigerich?
Voluntary forfeiture of all items seized.
Court will forfeit, order the forfeiture of all contraband and instrumentalities that were seized. Mr. Matthews, anything else?
Just procedurally, I file these things, then does he wait to hear back from you before preparing the entry?
Or he'll
Okay.
look and see, I guess.
Okay. Thank you.
present this morning in the matter of State of Ohio versus Matthew Warfel. These are case numbers 23 CR 1286, 1288, and 1290. We were last here on January 23rd of this year. At that time, the defendant pled guilty to an amended count 1 in each of those 3 cases, each of those counts being a felony 5 violation of protection order in violation of revised code 2919.27A2. The state moved to dismiss the balance of those indictments at the time of sentencing, and as part of the plea offer in this case, the state also entered nollies on case numbers 1289 and 1287, which were filed later that day after the change of plea hearing. This court ordered a pre-sentence report and victim impact statement. The pre-sentence report was completed. The victim in this case opted not to provide a victim impact statement, although the state did have contact with her, and the court set sentencing for today. The state is at an opportunity to review the report prior to coming into court today, and is prepared to proceed with sentencing. And I think I neglected to note for the record the defendant is present this morning with his attorney, Jim Matthews. Thank you.
Thank you. 1 second, please. Matthews, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, thank you. Your Honor, despite the fact that Mr. Werfel has been to prison a number of times, largely over similar behavior, we do feel that there is a distinction in this case in that the letters contained in all of these indictments were written while Mr. Werfel was at North Coast Behavioral, being restored to competency on a case out of the Mentor Municipal Court and the Willoughby Municipal Court for some of these. But Matt does want to ask to be put on probation. He is at a point in his life, he's 59 years old, he basically has nothing, and he is hoping that the court will give him an opportunity to get started on perhaps building some kind of a life sooner rather than later. His plan, if released, is to reside temporarily at Project Hope. He has been there before. He knows how to get a bed there. He then would be contacting the Social Security Administration, and hopefully there would be funds in his disability account that would have accumulated while he was at North Coast Behavioral. And with those, he would intend to secure an apartment, perhaps at the appropriate time seek employment, but basically try to just get started on having some semblance of a normal life and possessions. So in terms of the differences, I guess, between this case and previous cases have involved a violation of the order where he physically appeared at the victim's home. These cases are strictly him writing letters to the victim at her address, and I do feel that there is a point to be made about his state of mind. Again, not claiming that he's in any way not guilty by reason of insanity or out of control of his actions, but he was certainly in a diminished state of mind. Some of these were written before medication was forced upon him by Mentor Municipal Court. Some of them were written after. But he is asking that under those circumstances which are unique to his previous cases that the court placed him on community control. Thank you.
Thank you. Mr. Warfel, you have the right to address this court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Yes, Your Honor.
Go ahead.
Well, words get in the way of actions speak louder than words. And until I hear what you have to say, I can't really make a plan that I can follow. But I've been started over. I'm an adult child of an alcoholic. We have a problem finishing a project from start to finish, but we're real good 3-inning ball players. And long time ago, when I was 15, Judge Leotis Harris put me through a scared straight program down in Cleveland, and I didn't have no criminal trouble until '97, when this career, whatever you want to call it, started in my writing. Just a divorce handled in criminal court, and if we had lawyers and money, you know, it might have panned out different, but it is what it is, and it's gotten to this point now where, you know, it's got my attention, you know. Prison was no joke last time. In jail ain't no joke. They're working 12 hours. They don't have time to talk anymore. They're busy. Everyone's stressed. And it just ain't no fun anymore. And my biggest problem is, I wrote you once about 10 days in jail. You probably didn't understand that, but I wanted to quit smoking. And as long as I stay away from that first one, I'll be able to buy anything I want. And in AA, it says less problems of money, property, and prestige divert us from our primary purpose to stay sober and help other alcoholics to achieve sobriety. And I did 5 years probation, but I started smoking marijuana and started drinking a little bit here and there. And, you know, I can't blame it on that because I put it in me, but I also had a problem at my apartment where I should have took my stimulus money. Hindsight's 20/20. I should have took my money and rented a new place and got out of there because it wasn't healthy for me anymore. But community control, like I said, I know the community. Everything's within walking distance here. It's homeless friendly kind of, and I really, you know, been since 2012, since I've been at Project Hope, and started that low. But you know, I started back 5 years ago with nothing but a beanbag chair and a coffee table, and I did quite well. But I gave it all away by going to her house that morning, and you know, I don't know what I was thinking. I had money in my. I thought maybe the $1,000 I sent her in child support might have softened the blow, but there was only 2 months left on the protection order. And like I said, I don't always think through my actions. You know, sometimes I just act on impulse, and it gets me in a lot of trouble. Like now, you know, I wore the mask so I wouldn't talk so much, and you know, now I can't stop. You know, it's like my writing. It's a one-way conversation now. No one writes back, and what's the point of it? It's psychobabble, basically. You know, but I got to quit, you know, just cigarettes. It's just another thing that I started that it helps me sometimes, but it's not, this has gotten too serious. This is, you know, it's no joke. I mean, I like to use humor to lighten up the load sometimes, but, you know, this is my life, and what I've done to it as a result. You know, I know a lot of people out here, and, you know, the work around here, and it's become my family, you know, because I don't have much support in the Wardendu family that I come from. Family home sits vacant, and they make me live in whatever. But that's just toxic relationships that I formed with these people. And I want to help, but sometimes I got to help myself, and that's where I struggle. I'm good with the book. I know where to go look in the AA book. I know where all the meetings are. I know how to get back on my feet. I just need a chance. With that, I'll rest.
Thank you, sir. Mr. Matthews, anything else?
No, Your Honor.
Mr. Downing for the state of Ohio?
Thank you, Your Honor. You know, this is the conduct that we're dealing with today is spanning decades of the same or similar conduct, as this court is well aware. Through past dealings in the pre-sentence report, the defendant has numerous violation of protection order convictions. for same or similar conduct to what we're dealing with here today. In this particular case, this was a relatively large amount of violations, although the conduct itself on the scale of seriousness trends towards the lower end. As defense counsel pointed out, sending letters versus showing up. I think it's also important for the state to note that there was a large amount of violations in this case. We're dealing with 11 separate letters spanning over 7 months. And this is, like I said, the same or similar conduct as happened before. The state's going to recommend prison in this case, and is pursuant to the plea deal, the state's going to cap its recommendation to 2 years. And that recommendation is either largely or wholly based upon the defendant's record in this case. And the fact that this is not the first time or the second or the third time that we've dealt with this type of conduct with this victim with this protection order. It's just the same thing over and over again. And so the recommendation is based on punishment, also based on safety for the victim. The victim should not have to deal with this anymore, regardless of the type of conduct or the level of the conduct. And I think it's safe to say that the defendant can never contact this victim ever again. Although the victim is not here today and did not submit a victim impact statement, the state did have personal contact with her, and I don't think it's out of reason for the state to represent to this court that she is very sick of this and she's very tired of it, and it's taking a toll on her as well. So the state's asking for 2 years of prison in this case. I think it's appropriate given the defendant's history. And I don't think there's any other conditions of sentence that the state's going to ask for other than prison.
This court has reviewed the pre-sentence report and investigation. Consider the facts and circumstances of all the offenses involved, the nature of the offenses. What's been said here in open court by Mr. Warfel, his attorney, the prosecutor. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29:29:11 of the revised code. As for the factors in 29:29:12, the court does note that, again, the sheer number of letters that are written here, 11 separate letters within the period, 7-month period of time. The court also notes what makes this worse is just the repeated nature of the conduct. This has been going on, as mentioned, for decades, since the late 90s. The victim has suffered serious psychological harm as a result of the conduct. There's no reason that she needs to put up with this. She's doing what she needs to do by law to try to get it to stop, and the defendant just completely, blatantly ignores it. Over and over and over. She shouldn't have to put up with this for 25 years now. 25 years she's been having to deal with this. As for factors indicating it's less serious, the court does note, as pointed out, that it was not personal contact, but nonetheless, these letters are, it's not the same as personal contact, so I'll make that binding. As for recidivism factors, the court finds the defendant was on post-release control at the time he committed these offenses. He had charges pending against him in Mentor Municipal Court at the time he committed these offenses. He has an extensive history of criminal convictions, including extensive history of violating protection orders. He demonstrated it doesn't matter what courts or anyone says, he's going to do what he wants to do. No factors indicate recidivism is less likely. Under 29:29:13B1, and these findings are all for all 3 cases. Under 29:29:13B1, the court finds the defendant has previously served a prison term, was on post-release control at the time. Prison is consistent with the purposes and principles of sentencing. The defendant is not amenable to available community control sanctions. Therefore, it will be the sentence of this court that on each of the 3 cases, the defendant served a term in prison of 11 months. I'm going to run the prison terms in 23 CR 1280, 1286, and 1288 consecutive to each other. case, the prison term in 23 CR 1290 will be concurrent to those two cases for an overall total of 22 months in prison. In case 23 CR 1286, defendant has 307 days of credit. There's no credit in 1288 since it's consecutive. In 1290, there's 99 days of credit. Need to advise you upon your release from prison. I'm not going to add any additional time for post-release control violation. It's up to the parole authority. If they determine they want to violate, punish you, they can do that, but I presume they won't, because they never do. That's their job. I need to advise you upon your release from prison, you could be put on post-release control for these cases for up to 2 years. If you are and you're violating any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. And the balance of all the other counts in each of the 3 indictments, 23 CR 1286, counts 2, 3, and 4 dismissed. In case 23 CR 1288, that was just the 1 count. 23 CR 1290, count 2 is dismissed. Anything else for the record, Mr. Downing?
No, Your Honor, thank you.
Mr. Matthews?
Just, is the net effect of this 22 months with credit for the,
About 10 months, so he's got just about a year, just
Okay.
a tad under a year.
okay, thank you.
Basically has, what's a year, 30? 10 months credit, this would be 300 days, so he has 7 days short of a year.
Thank you.
All rise. Thank you, Your Honor. We're present in the matter of State of Ohio versus Ricky Tripotto, case number 24CR000062. The defendant is present in court with defense counsel Mary Springer. On January 12th, 2024, the defendant was indicted in a 14-count indictment. Prior to coming into court today, the state has extended the following offer to the defendant, that the defendant plead guilty to count 3, aggravated trafficking in drugs, felony of the 3rd degree, count 5, aggravated trafficking in drugs, felony of the 3rd degree, and count 8, aggravated possession of drugs, a felony of the 3rd degree. The state would request a pre-sentence report as part of that plea agreement, and that offer is valid, provided the defendant does not violate any conditions of his bond, commit any new offenses, and appears at all court hearings. Thank you.
What does this all entail? Can you just summarize in regards to the charges?
Your Honor, this is an investigation that was conducted by the Lake County Narcotics Agency that involves 3 controlled buys on 3 different dates, as well as a search warrant in which a customer was present when the search warrant was conducted.
Give me a customer, someone that's buying drugs?
Correct. So another buy had just occurred at that time, and several items of narcotics were also located during the search warrant.
I don't have it. In terms of the indictment, I'm not sure if I have it right in front of me. Are any of these mandatory prison?
No, Your Honor.
We have 3 with probably presumption, I'm assuming. At least some of them.
Yes.
What's the defendant's history like?
Looks like, Your Honor, just misdemeanors from 2015 to 2021. I have 7 misdemeanors in the Willoughby Municipal Court.
Is he on probation or anything at the time any of this happened?
Not to my knowledge.
Ms. Springer, you received the state's offer?
Yes, Your
Did
Honor.
you just get that today?
Yes.
Okay, so you obviously haven't chatted with your client about that.
I made him aware of it, but we haven't gone into it in any detail.
That's fine. Any issues that you're aware of that will be requiring like an evidentiary hearing that we need to schedule?
No, it does not appear like there would be any motions filed that would need an evidentiary hearing.
Okay. Anything else you want to discuss?
Not at this time. Thank you.
All right, Mr. Is it Tripotto? Did I say that right?
Yes.
Tripotto. Your attorney was given an offer by the state today, and I know you just got it, so I'm not asking for any responses. You'll take time and go over it and discuss it with her. The court does need to know, however, 2 weeks before the trial date whether you're going to accept the state's offer or not. Now, the trial in this case is April 16th, so you have plenty of time at this point. We don't need to know until, what would that be, April 2nd, whether you're going to accept the offer. You can let us know ahead of time if you want to, but we need to know at least by the April 2nd. Understand that?
Yes.
Okay. You are on an own recognizance bond, which means you didn't have to post any money. You just signed your signature as your bond, basically. But when you're on an own recognizance bond, you need to appear at all future court dates. And if you fail to do that, that could be a separate felony that you can be prosecuted for. That's a felony of the 4th degree, up to 18 additional months in prison, in addition to anything that can happen here. So it's obviously important you show up at all future court dates. Now, right now, your trial is scheduled for April 16th at 8:30 in the morning. You understand that?
Okay.
If this is going to be a change of plea, after you chat with your attorney, and again, we have over a month to 5-6 weeks before we need to know about that. It will be on a different date. It won't be on that trial date. It'll be before that. So you'll have to appear at that court date as well. So don't assume that if it's going to be a plea that you work this out, that you're just going to show up on April 16th and enter your plea. It won't be on that day. It'll be a different day before that.
Okay.
So make sure you find that out, all right? Because if you fail to appear on that day before that, I don't want you coming in saying, well, I was coming in on the 16th to enter my plea. That's not the way. There'll be another trial going on that day. So it'll be before that. You understand that?
Yes.
All right. Any questions about any of that kind of, I don't want to talk about the case at all, but just you understand when your next hearing date is right now is the 16th, and it could be before if you work out a plea.
Yes.
All right, anything else we need to discuss?
No, Your Honor, thank you. No, Your Honor,
All
thank
right,
you.
thank you both.
All rise.
Matter of State of Ohio versus Brianna Law, case number 20 CR 0011314. The defendant is present with defense counsel Conchetta Vergazione. We were previously in court on January 22nd, 2024, where the defendant pled guilty to count 1, possession of a fentanyl-related compound, a felony of the 5th degree, in violation of revised code section 292511A, with an attached forfeiture specification, and count 4, possession of a fentanyl-related compound, a felony of the 5th degree, in violation of revised code section 2925.11A, with an attached forfeiture specification. The court at that time found the defendant guilty and ordered pre-sentence investigation and report and drug and alcohol evaluation. The state has had the opportunity to review those reports and is prepared to proceed with sentencing. Thank you.
Mr. Graziano, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. I would ask this court to find Ms. Law amenable to community control sanctions in this matter. As part of that, I would ask the court to allow her to continue the treatment that she is doing with Brightview. Ms. Law does reside in Akron, and she is attending treatment at Brightview in that area. She is also working. She is actually working 2 jobs. She works as a cleaner for a hotel, and then she also works doing similar work, janitorial work, at a factory called Step 2. So in explaining her work schedule to me, she is, her work and treatment schedule, she is keeping herself very busy. She works Monday through Fridays from 8 to 6 at her full-time job cleaning the hotel. She does leave that job on Mondays and Wednesdays from 1 until 3 to do her treatment at Brightview to engage in IOP. And then she works her part-time job in the evenings on Mondays, Wednesdays, and Fridays. So she is keeping herself very much occupied. As of now, she is still doing well. She does recognize that she's been struggling with substances for some time. When we look at her record and the pending cases that she has, it's very clear that her addiction has been out of control. But she does feel like now she has been able to get some structure and get some control of that. She is currently on GPS monitoring as part of a bond condition in one of her other cases. So she has been doing well as of recently. She is eager to take care of all of these cases that she has. She is married. Her husband is good support for her. He is here in the courtroom with her today. She is expecting another child. So she is really wanting to turn things around, to be a good citizen, to be a good parent. She does have 3 other children, and she really is hopeful that she can continue moving forward. She has spent 6 days in the jail on this case, so she does have 6 days of credit. Thank you.
While you have the right to address the court before your sentence, you can say anything you'd like. Is there anything you want to say at this time?
Yes, Your Honor. I did struggle with opiates for a really long time, from when I was 18 all the way to 25. I've been sober for about 5 months now. Well, almost 5 months. Next month will make it 5 months. I'm trying to get my life together. As she said, I am working 2 jobs. I do have another child on the way. I just dealt with the passing of my mom, so one of the things that she wanted was for me to stay sober. So that's what I'm trying to do.
and anything else?
Your Honor, I guess I would just also point out that in the pre-sentence report, I think it's evident that Ms. Law does have some trauma in her background, that, you know, potentially that's been part of what has driven this substance abuse issue. I think that's something that she could benefit from working on. And I would just also state that she, you know, she did have these pending other cases. She was out on a warrant in this case, and she's really realized that, you know, she just has to face the music. She's really hopeful to be able to, again, just get all these things behind her and be able to move forward and be productive. Thank you.
Ms. Ronick for the state of Ohio?
Thank you, Your Honor. The state does recognize that the defendant is currently in treatment, doing medication-assisted treatment and IOP and mental health, and has been clean for 4 to 5 months, which may be the longest since her drug habit
She
began.
was arrested November 9th for another drug charge, right?
Correct, yes. And I believe that is the date of sobriety that is reflected in the pre-sentence report, is either November 8th or November 9th. And that is when she was picked up out in the Summit County area and how she got returned to Lake County to face these charges. However, so based on the treatment and her current sobriety, the state is going to join in the defense's recommendation for community control. However, the defendant does have a long history of noncompliance, especially for someone so young. A lot of cases that were picked up in the time that since she's been an adult, and then that does not include the cases that she had as a juvenile. And she was out on a warrant for several years on this case, which was committed while she was out on another warrant on a different case in Summit County. And during that time, she continued to commit crimes. She continued to pick up new cases. She continued to use drugs with no real consequences. So as part of the community control sanctions, the state is requesting that the court impose a jail term to reflect the behavior of the defendant during the time that this case has been pending and before. The state would also ask that the defendant be ordered to continue with her current treatment and to undergo periodic screens. Thank you.
This court did review the pre-sentence report investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the underlying offense, the nature of the offense. What's been said here in court. I don't have a docket sheet on this. It's a 20 case. It's 20 CR. What is it?
13-14.
1314. Again, I consider what's been said here in court by Ms. Ragazione, the defendant herself, the prosecutor, the recommendations. All this is considered by the court in light of purposes and principles of felony sentencing set forth in 292911 of the revised code. Factors in 292912, factors indicating the conduct is more or less serious. There's nothing factually about this case that would indicate it's any more or less serious than what normally constitutes the commission of this offense.
She says check the 23 files. In the wrong file.
There's no factors indicating the conduct is more or less serious than what normally constitutes this offense. As for the recidivism factors, however, many of these factors are present. The defendant does have a history of juvenile delinquency adjudications as well as convictions as an adult. She was on probation to Lorain County when she committed this offense, and she was also on bond to Lorain County for another case when she committed this offense. She has not responded favorably in the past to previously imposed sanctions. There are many probation violations on her in her history. She's been given opportunities. She had intervention in lieu of conviction. Just didn't show up for things. She never did. And that's part of the problem here is there's never been any consequences. They would just give her another chance, and she would never show up. In this case, court notes that she violated her bond by failing to appear. She was gone for 2.5 years in this case. Committing offenses while she's on bond, while she's on probation. Bond. In this case, she picked up a new offense, or not strike when the warrant was out for her. Just recently, she's got new charges now from November of last year of 23, which she committed while she was a fugitive in this case. Factors indicate recidivism is less likely. Under 2913B1, the court again finds defendant was on probation and bond when she committed the offenses in this case, which is a factor that does override the presumption for probation, permits the court to impose a prison sentence without having to make any special findings for doing that. Despite the absence of the presumption, I will find at this time that prison would not be consistent with the purposes and principles of sentencing. The defendant would be amenable to available community control sanctions. Put the defendant on community control sanctions for a period of 2 years. However, there does have to be consequences, and that's part of the problem here is that she's never had consequences. She just continually would flaunt the court's orders and nothing would happen to her. The court's going to order as condition of probation that she serve 60 days in the Lake County Jail. She has credit for 6 days she's served. I'm going to order that she enter and successfully complete the jail treatment program, follow all their aftercare recommendations. Upon completion of the jail treatment program, I'm going to order that and permit her supervision of her probation to be transferred to Summit County. As conditions of your probation, further conditions, you're not to use any drugs or alcohol. You have to submit random urine screens. They have to be negative. Positive screens a violation.
Can I say something?
You already had, not at this time. At the end, I'll ask you questions. I'm going to order that you attend 3 AA meetings a week and have a sponsor. Obtain and maintain full-time employment or education. Continue with mental health counseling at Brightview. Continue with your medically assisted treatment. You're going to have 1 doctor and 1 dentist that can prescribe you medication, 1 pharmacy where you get them filled. You're to take all medications as prescribed. Pay your court costs and supervision fees. Order the forfeiture of the contraband and instrumentalities. Counts 2 and 3 will be dismissed pursuant to the agreement. Ms. Law, you understand all the conditions of your probation? Any questions for me at this time?
Yes. I know you said I didn't have any consequences, but I did. It might not show up in there, but I have lost my children. I have completely lost them. I am trying so hard to get back stable. I don't feel like going to jail is going to help me. I'm trying to stay sober. I'm doing it. Like, I'm finally doing it. Everything that you heard before with me running or doing something like that, it's because I was high. I was literally high. I wasn't me. This doesn't help people. It really doesn't. I spent a long time in Summit County Jail. Very long time, almost a year, all put together. I have served a lot of time. And whenever you said I was running for 2 years, I really wasn't. That's when COVID hit.
So?
So they wouldn't take me.
Who wouldn't take you?
The cops, whenever I was stopped, they would not take me.
Did you come to the sheriff? Did you come here?
I didn't know if I could do that because they said I couldn't even, they weren't going to arrest me. So I figured I just couldn't even turn myself in. I know you think this is gonna help me, but this is gonna make me lose my job. I'm gonna have to start all over. Like, I'm finally sober, finally, and I want
You
this.
got 1 job 2 weeks ago.
No, I've had it for a very long time.
Both jobs?
The one job was about 3 weeks ago, then the other one I've had for almost 2 months. Like, I'm trying really hard. Judge, I'm really trying. And if you gave me a chance to show you that without sending me away, like, I'm not gonna
sending you away.
disappoint you. I'm not.
I'm not sending you away.
Well,
You're
to
going
jail.
prison for 2 years.
To jail. I won't disappoint you. I'm sober. I'm able to think. I don't want to use drugs. I don't want to do that. I know that it has consequences and it ruined my entire life. I'm just trying to get back stable. I'm finally able to think. Like, I'm not who I was. I'm really not.
Do you have any questions regarding the conditions of your probation?
No.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you were to commit another crime while you're on probation, and I'm not talking about resolving anything that's pending. You resolve those however you think you need to resolve those. I'm talking about new acts from this day forward. If anything like that should happen, a motion to terminate your probation will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate or end your probation and send you to prison. If I did that, it'd be 12 months on each count consecutive, and it'll be consecutive to any other prison term you may be serving, but that gets imposed at the time. You understand that?
Yes.
All right. Anything else for the record, Ms. Ronick?
No, Your Honor, thank you.
Ms. Ragazio?
No, Your Honor, thank you.
Hearing case numbers 23 CR 438 and 23 CR 879, State of Ohio versus Alan Glavick. Your Honor, on 23 CR 438, we were last together on September 25th of 2023, where defendant entered a plea of guilty to complicity to breaking and entering, felony of the 5th degree. And in 23 CR 879, we were here on February 9th, where defendant entered a plea of guilty to a felony of the 5th degree, count 1 vandalism. Your Honor, we are set today for a sentencing. There is no joint recommendation, however, I would just bring to the court's attention at the last time we were here on the 438 case, the state indicated and maintains that we would not be taking a position whether or not we would ask for concurrent or consecutive time on that case, but would only be asking for a prison sentence in that case. The basis for that was that the co-defendant in that case received concurrent time on his case that he had already been serving. Thank you, Judge.
Thank you. Mr. Hinton, any reason not to go forward with sentencing?
No such reason, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. On behalf of Mr. Glavick, I would indicate that as the court knows, on case number 22 CR 000 458, Mr. Glavick is serving a prison sentence on May 15th of 2023. He was sentenced to a total of 40 months in the institution with credit for 106 days. As far as the instant cases go, they're both felonies of the 5th degree. And although any presumption for community control could be rebutted based on various statutes, we would ask the court to consider community control sanctions. As far as the fact that Mr. Glavick is currently serving a prison sentence, we did file a motion for judicial release in said case. In the alternative, if the court was not inclined to do that, what we would ask the court to do is to render concurrent sentences in both pending matters and fashion those so that those sentences run concurrent with each other and concurrent with 22 CR 000 458. The reason being on the 23 CR 000 438 attempt or complicity to breaking and entering would be again the fact that the co-defendant received a concurrent sentence. I think the circumstances were similar as far as that individual being on bond or having a prison sentence that was upcoming or something that was similar to Mr. Glavick's situation. So I think that would be reason for a concurrent sentence on said case. As to the other case, the vandalism case, as the court is aware, that had to do with the window in the holding cell downstairs. It's my understanding that it had a low value. It was around $150 some. So in a lot of situations that could be a misdemeanor. In this situation it wasn't, because it was charged under the statute that indicates that window was necessary for the sheriff's department or the court to run. And we recognize that and understand it, but we think that what I just stated is mitigation and reason to order a concurrent sentence. Thank you, Your Honor.
Thank you. Mr. Glavick, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
I'm willing to pay for the window, $115. Like I told you 2 weeks ago, I was not on meds, out of control, unstable. Doing okay now.
Is there anything else you'd like to say?
No, sir.
Mr. Hinton, anything else on behalf of the defense?
I would just reiterate what he indicated as far as his mental state. Again, just using it for mitigation. I know he was really upset that morning. He had been charged with the breaking and entering case. Now that he's had some time to get his meds straightened out, he seems to be comprehending everything much more thoroughly. Thank you.
Mr. Foyce, on behalf of the state.
Thank you, Your Honor.
Your Honor, the state is of the belief Mr. Glavick is not a good candidate for community control at this time. We do think prison is appropriate. In regards to the 23 CR 438 case, at that time that case was committed, the defendant had been out on bond pending trial, actually, I think in this case, in this courtroom. Your Honor, in regards to the 879 case, the defendant was actually in our jail for that case. He's not necessarily a person that would be considered to be a good candidate for community control. We would ask that the court not consider community control for Mr. Glavick and actually give him a prison sentence on each of these cases. Your Honor, regarding the restitution request, there is a restitution request in the 879 case for $115. And just to clarify a little bit what Mr. Hinton said, the co-defendant in the 438 case did have quite a history as well and was awaiting trial himself and had prior prison numbers as well, but was still given the concurrent time on his case. So that's just a little bit of a backdrop or background on that case. So, Your Honor, we would ask again, prison in both of these cases. We do think it's appropriate. We do not think he would be a good candidate for community control.
This court has considered the particular facts and circumstances of the offenses involved in these two cases, the nature of those offenses. I've considered what's been said here in open court by Mr. Hinton, Mr. Glavick, the prosecutor, requests and recommendations by everyone. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, nothing stands out to the court for either of these cases, which would indicate it's more or less serious than what normally constitutes the commission of these offenses. As for recidivism factors, the court finds the defendant has a history of criminal convictions. He has failed to comply in the past with previously imposed sanctions ordered by courts. He was on bond in 22 CR 458 when he committed the offense in 23 CR 438. He was serving a prison sentence when he committed the offense in 23 CR 879. Nothing indicates recidivism is less likely. 29-29-13 B1. These findings are for both cases. Court finds the defendant has previously served a prison term. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that in case 23 CR 438, then it be sentenced to serve a term in prison on amended count 2 of 6 months in prison. In that case, he has 18 days of credit because he was out on bond at the time when he committed that, and then when he got arrested, he was in solely on this case until the day of his sentencing on the case he's currently serving a sentence for. Court's going to order in case 23 CR 879, going to serve a term in prison of 6 months. No credit on that case. Court will order that the 2 6-month prison terms be served concurrent with each other but consecutive to the sentence he's currently serving. I need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you violate any of the conditions of your post-release control, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court does find that the 2 6-month terms that I ordered to be served consecutive to what he's currently serving is necessary to protect the public from future crime and to punish the offender. They're not disproportionate to the seriousness of his conduct and to the danger he poses to the public, and that he committed one or more of the multiple offenses while he was on bond to this court in another case, and his history of criminal conduct demonstrates consecutive sentences are necessary to protect the public from future crime by the offender. In case 23, CR 879, the court will order restitution. What's the amount again, Mr. Foisel?
$115?
15?
Yes, 115.
$115. Defendant's order to pay all costs. Case 23, CR 438, the court will dismiss the balance of that indictment as agreed to. I think that covers everything. Mr. Foisel, anything else for the record?
Nothing further from the state, Your Honor.
Mr. Hinton?
I get it.
Nothing further, Your Honor.
Oh,